Hi, this is Alexandra Kitty. Welcome to True Crime, Wrong Story, the podcast that goes into the details that other true crime podcasts don't dare ask. So, for today's episode, we're going to see what happens when the sin of omission is the evidence itself. So, we're going to look at the plight of Calvin Johnson, an innocent man convicted of something he clearly did not do. And he his evidence was taken into a very unusual place. And well, you're just going to have to watch this episode to find out what was done and how it was resolved. So let's go. Clayton County, Georgia. Calvin Johnson was convicted of rape and sentenced to life in prison. The primary evidence against him? Eyewitness identification. The victim picked him out of a lineup. He was sent to Georgia State Prison, and for the next 16 years, he had said the same thing over and over. I didn't do this. You have the wrong man. By the 1990s, testing had revolutionized criminal justice. It could prove scientifically whether someone was guilty or innocent. The Innocence Project took Calvin Johnson's case. They requested DNA testing on the biological evidence from his trial, the rape kit collected in 1983, and Clayton County sent back a letter. Evidence no longer available, case closed, no testing possible. And so Calvin Johnson stayed in prison. Years passed, 1995, 1996, 1997. The evidence that could free him was officially gone, except it wasn't gone. It had been thrown out, literally, placed in a courthouse parking lot next to a dumpster waiting to be hauled away. And then a district attorney walked past. He saw boxes marked evidence, and he made a choice. He pulled them out, and he put them on a shelf. Years later, the Innocence Project tracked that DA down, and inside those boxes he saved, there was Calvin Johnson's rape kit. DNA testing in 1998. Results? Johnson was not the rapist. 1999, after 16 years, he was exonerated and released. But here's the question. What if that district attorney hadn't walked past that dumpster that day? What if he kept walking? I'm Alexandra Kitty. This is True Crime, Wrong Story. And this is the story of how close Calvin Johnson came to dying in prison because someone threw his evidence in the trash. Let's start with how Calvin Johnson ended up in prison. 1983, Clayton County, Georgia. A woman was raped. She gave police a description of her attacker. Calvin Johnson was arrested, put in a lineup, and the victim identified him. Eyewitness identification. It feels powerful in court, a victim pointing at the person who hurt them. But it's also the leading cause of wrongful convictions. 72% of DNA exoneration cases involved eyewitness misidentification. At Johnson's trial, there was biological evidence. A rape kit had been collected. But in 1983, DNA testing wasn't available yet, so the rape kit sat in evidence unused. All the prosecution had was the victim's identification, and a jury believed her guilty. Life sentence plus additional terms. Calvin Johnson went to prison, and he spent the next 16 years saying he was innocent. By the mid-1990s, something had changed. DNA testing had become reliable, accurate, and it was starting to prove that some people in prison, people convicted of on eyewitness testimony, were innocent. In 1989, the first DNA exoneration happened in the United States. By the mid-1990s, it was clear. If you had biological evidence from a crime, DNA could tell you definitively whether the convicted person was guilty. And Calvin Johnson had biological evidence, the rape kit, sitting in a Clayton County evidence room somewhere. If they could test it, they could prove whether he was guilty or innocent. The Innocence Project took Johnson's case in the mid-1990s. They did what they always do. They filed a formal request with Clayton County for the biological evidence from his trial. We need that rape kit. We need the swabs, the slides, anything with biological material. We want to do DNA testing. And then they waited for the results. It came back. The evidence is no longer available. No longer available. That's it. No explanation, no details. Just, we don't have it. And when there's no evidence, there's no DNA test. And when there's no DNA test, there's no exoneration. This is where a huge number of Innocent Project cases end. Between 2004 and 2015, 29% of cases, nearly 1 in 3, were closed because evidence was lost or destroyed. Not because the person was guilty, but because the proof was gone. So Calvin Johnson stayed in prison 1995, 1996, 1997. The years stacked up. The system had told him, your evidence is gone. There's nothing we can do. But gone is a strange word, because Johnson's evidence wasn't lost in a flood. It didn't burn in a fire. It didn't disappear mysteriously. It was thrown away on purpose as policy. So this is what happened to Calvin Johnson's evidence. In Clayton County, Georgia, trial exhibits, evidence from cases were stored in a closet by the court stenographer. Not an evidence room, not a secure facility, a closet. When that stenographer retired, he was given instructions, throw everything out. This wasn't negligence. This wasn't an accident. This was the standard file destruction policy. All trial exhibits, decades of evidence, rape kits, DNA samples, everything that could prove someone innocent or guilty, wheeled out to the parking lot and placed next to a dumpster. Calvin Johnson's evidence was in one of those boxes, scheduled to be hauled away forever. And that would have been the end of it, except a district attorney happened to walk past. He saw boxes marked evidence, and he stopped. He had two choices. Keep walking, let the trash service take them, follow policy, or pull them out. He pulled them out, carried them inside, put them on a shelf in a back room. Not because any rule told him to do it, just because he thought maybe we shouldn't throw this away. And that decision, that one moment, is the only reason Calvin Johnson is free today. Years later, late 1990s, the Innocence Project was still looking for Johnson's evidence. They'd been told it was gone, but they kept digging. And eventually, they found the district attorney who had pulled those boxes from the trash. Do you remember grabbing evidence boxes from a dumpster area? Do you still have them? He did. He took them to a storage room, pointed to a shelf. There, inside one of those boxes, Calvin Johnson's rape kit. The swabs, the slides, the biological evidence from 1983 that everyone thought was gone. 1998, DNA testing. Results? Calvin Johnson was excluded as the source of the semen in the rape kit. He wasn't the rapist. The victim had identified the wrong man. June 1999. After 16 years in prison, Calvin Johnson was exonerated and released. But look how close he came to never coming out. If that DA had walked past that dumpster one day earlier, before he noticed the boxes, they would have been hauled away. If he decided it wasn't his problem, they would have been hauled away. If he thought someone else will deal with it, they would have been hauled away. And Calvin Johnson would have spent the rest of his life in prison for a rape that he didn't commit. His freedom came down to 2 cotton swabs from a rape kit and one person who happened to walk past the dumpster at exactly the right moment. Calvin Johnson is one of the lucky ones. But 29% of Innocent Project cases between 2004 and 2015 were closed because the evidence was lost or destroyed. Roughly 1 in 4 potential exonerations fail, not because of guilt, but because the proof is gone. Since 1989, there have been over 375 DNA exonerations in the United States. But if 1 in 4 cases can't proceed due to missing evidence, that means there are hundreds, maybe thousands of people still in prison who could have been freed if only the evidence still existed. There's no uniform standard for evidence preservation. 3 states, Delaware, North Dakota, and Vermont, have no evidence preservation laws at all. Most states have weak or inconsistent rules, and there's no federal requirement, which means in many jurisdictions, destroying evidence after conviction is standard practice, not because of bad actors, because of policy. In Canada, in the 1970s, an RCMP investigation file from 1969 was destroyed as regular file destruction policy. Decades later, that made it impossible to properly review David Milgard's wrongful conviction case. An innocence attorney described the reality. In some cases, we've had to search old warehouses, evidence lockers, and even coroner's offices to find samples that should have been retained. and sometimes we find out it was thrown out long ago. So you have cases like David Milgaard in Canada, where evidence was preserved for 27 years and DNA testing eventually exonerated him. And you have countless other cases where files were destroyed per policy and wrongful convictions could never be reviewed. It's arbitrary. It's location dependent. And it means whether you get exonerated can depend on whether someone in an evidence room decides to keep your box or throw it away. Law professor Brandon Garrett had put it bluntly. We will never know how many innocent people could have been freed if evidence had been preserved in the 1970s, 80s, and 90s. So let's talk about what actually was omitted from this story. When Clayton County told the Innocence Project that Calvin Johnson's evidence was no longer available, that was technically true. But it was a very specific kind of true. Loss makes it sound like an accident, just like evidence disappeared. But the evidence didn't disappear. It was ordered destroyed. Someone gave the instructions. Someone followed it. And the boxes of evidence ended up in a dumpster. What's actually missing from the system? A federal standard for evidence retention, uniform state laws, mandatory preservation during incarceration, accountability when evidence is destroyed. None of that exists. So what you end up with is this. Calvin Johnson, if you can say it, got lucky. Someone walked past his dumpster. Someone cared, and someone made the right choice. But for every person like him, how many others weren't saved? The omission is at the heart of this case, isn't just Johnson's evidence that almost got thrown away. It's all the evidence that was thrown away in other cases where no one happened to walk by. And it's all the people still in prison right now because the proof of their innocence was destroyed before anyone can test it. And for every innocent person incarcerated, there's the true guilty people who are walking free. And that's the real omission. Not a single piece of missing evidence, but a system that routinely destroys evidence and calls it policy. So now let's ask Perplexity a question regarding this case. How does the Calvin Johnson case change the way we should design systems of evidence storage and review? And if you and I were to put in charge of rebuilding those systems from scratch, what concrete rules and safeguards would you insist on so no one's freedom ever depends on a random DA walking past a dumpster?
Johnson's case is the purest proof that evidence storage and review can't depend on individual heroism or random luck. The system has to be engineered so that no single person, office, or court can take innocence to the dumpster and back. What Johnson's case reveals, the rape kit evidence that cleared Johnson was sitting in a closet, slated for destruction, when a court stenographer retired and was told to throw everything away. A prosecutor happened to notice boxes labeled evidence near or in a courthouse dumpster and decided to save them, which ultimately allowed DNA testing to exonerate Johnson after 16 years in prison. This isn't a one-off. Other exonerees, like Dennis Maher, Kevin Bird, and Marvin Anderson, were freed only because evidence was accidentally retained or mistakenly, not destroyed. Design lesson. The current system is incident-driven and personality-dependent, when it should be infrastructure-driven and procedure-locked. Design principles if we rebuilt from scratch. If you and I are rebuilding, the backbone is no single actor can quietly lose, destroy, or bury evidence. And every piece of evidence has a digital life that outlives the humans who handled it. Core principles. Default to preservation. Law sets a strong presumption that potentially exculpatory evidence is preserved for the life of the sentence plus a defined tail, especially where biological material exists. System. Not heroism. No one should need a DA with a conscience wandering past a dumpster. All crucial steps must be automated, logged, and audited. Independent oversight. Evidence policy and enforcement sit with an independent body, not solely with police or prosecutors. Echoing recommendations for external oversight of forensic systems. Learning from error. Wrongful convictions and near misses trigger systemic review, not quiet one-off fixes. Concrete rules for storage. Here's the kind of rules I'd insist on for physical and digital evidence handling. 1. Mandatory cataloging and barcoding. Every piece of physical evidence, rape kits, clothing, slides, swabs, notes, is barcoded and entered into a unified evidence management system at collection, with unique IDs that follow it from crime scene to lab to courtroom to archive. Chain of custody is fully digital. Every transfer, location change, or access event is time-stamped and user-stamped, with immutable logs. 2. Centralized professional evidence repositories. Evidence is never stored in ad hoc locations, stenographer closets, prosecutor offices, detectives' desks. It must be in accredited repositories or labs that meet national or international standards, a direction already pushed for forensic labs. Facilities have environmental controls, security, and standardized retention practices, subject to external accreditation and inspection. 3. Retention rules tied to human life, not office convenience. For any case where a person is incarcerated or under supervision, biological and key physical evidence is preserved at least for the term of confinement plus a substantial buffer, e.g., 10 to 20 years, or for life and serious violent felonies. No destruction is permitted if the defendant is in custody or on parole, there is an unresolved claim of innocence, or evidence is suitable for more advanced testing, e.g., DNA. 4. Destruction as a tightly controlled exception. Destruction requires written, recorded justification, independent sign-off, e.g. from a preservation board, verified notice to the defendant and counsel, and a waiting period in which objections can be filed. Automatic unreviewed purges like clean out the closet when you retire are explicitly prohibited by statute. Johnson's evidence should never have been on the chopping block this way. 5. Redundancy and backup. Critical items, e.g. rape kits, are mirrored, detailed digital documentation, photos, scans, lab reports, and where feasible, split or duplicate samples stored in separate locations to reduce risk of total loss. Digital records are backed up across multiple secure servers with integrity checks and access controls. Concrete rules for review and access. The other half of avoiding dumpster justice is how evidence can be found and retested when the system gets it wrong. 1. Statutory right to evidence and testing. Defendants get a clear legal right to access preserved evidence and to request modern testing when it can be materially probative of guilt or innocence without being blocked by technicalities. The standard for access is generous. We accept that the cost of testing is trivial compared to the cost of a wrongful life sentence. 2. Independent Post-Conviction Evidence Unit. Create a standing, independent post-conviction evidence and integrity office with authority to locate and review evidence across agencies, dedicated investigators and data analysts, formal channels to work with innocence organizations. This body can't be controlled by the original trial office. It reports to a statewide or national oversight structure. 3. Automatic evidence review triggers. Certain events automatically trigger a structured evidence review. Credible innocence claims. Pattern recognition that the same lab analyst officer has been implicated in other exonerations or forensic problems. Major technique discrediting, e.g. a class of forensic methods found unreliable. The review examines whether evidence exists, its condition, and whether new testing could be exculpatory. 4. Full transparency around forensic performance labs. Must maintain and disclose quality control logs, error reports, contamination logs, and audit reports, which defense can access under standardized rules. A public repository of forensic-related transcripts, pleadings, and research, something defense groups have advocated, creates a knowledge commons around what methods fail and how. 5. Learning loops from exonerations. Every exoneration involving forensic or evidence handling failure is treated like an aviation crash investigation. Root cause analysis, published findings, and mandatory corrective action for all relevant agencies. This includes identifying policy failures, like ad hoc storage, and codifying the fixes across the system, not just in the original county. Specific no dumpster safeguards. If we were writing the rulebook, I'd want explicit guardrails that speak directly to Johnson-style near misses. Anti-ad hoc storage rule. No evidentiary material may be stored in personal spaces, closets, offices, trunks. Any such storage is a disciplinary offense, and agencies must conduct periodic sweeps to detect it. Johnson's evidence should never have been in a stenographer's closet to begin with. Exit procedures for staff. When anyone with custody of evidence retires, resigns, or transfers, a mandatory evidence reconciliation audit is triggered, with sign-off by the repository and the Independent Oversight Office. Dumpster-proof protocols. Evidence may not be discarded in regular waste streams. Destruction for truly non-probative items must use secure destruction vendors with itemized logs that are reconciled against the digital inventory. Digital heartbeat for evidence. The central system automatically flags any item that hasn't had a status confirmation scan within a set period, prompting a physical check. Lost status triggers investigation and reporting requirements. Whistleblower and anomaly reporting. Any staff who sees evidence in an improper location or protocol violation has a protected channel to report it, with automatic logging and follow-up. The DA in Johnson's case shouldn't have to rely on personal initiative alone. If you and I were in charge, practically I'd see the architecture like this. The Calvin Johnson story is already a design spec in negative. Every step where his evidence was almost lost becomes a system checkpoint we can harden so that the next person's freedom never depends on who happens to walk past the trash that day.
Calvin Johnson's case came down to one moment. If the district attorney had kept walking that day, his evidence would have been hauled away. Because he stopped, because he pulled those boxes out, Johnson is free today. But here's another problem. An entire justice system shouldn't be built on hoping that someone happens to walk past the right dumpster at the right time. Freedom came down to 2 cotton swabs and one person who decided to save them. The system that almost threw away his evidence is still throwing away evidence to this day. Talk about a close call. I mean, a dumpster where we have put evidence that can exonerate an innocent man. It is quite remarkable. So next week is the finale. Not the last season, but the last episode of the season in podcast form. And then the following week, week 7, we're actually going to get a video game based on the theme of this season. So I'm very excited. More information later on. And then there'll be more information about the theme of season 3. But until then, this is Alexandra Kitty. Ta-ta for now.